We'll go now to Section 6 of your Rule 110, the sufficiency of complaint or information. So when is a complaint or an information sufficient? Answer is if it states the 6 enumeration. Ano ba yung 6 na enumerated? First is the name of the accused. Second is the designation of the offense given by the statute. Number 3 is the acts or omission complained of as constituting the offense. You have fourth is the name of the offended party. Fifth is the approximate date of the commission of the offense. And sixth is the place where the offense was committed. So take note of the 6. Second paragraph of your section 6 is when an offense is committed by more than one person, then you have to name them. All of them should be included in the complaint or information. Again, this is just a reiteration of your section 2 of Rule 110. Ito yung pinag-uusapan natin na general requirements. The complaint or information should be in writing, and your plaintiff is the people of the Philippines, and as far as accused is concerned, they should be named, or all persons who appear to be responsible for the offense should be included in the complaint or information. So we'll discuss first the name of the accused. This is your section 7 of your Rule 110. So if the name of the accused is known, then you have no problem because all you have to do is state the name and surname of the accused in the complaint or information. Ilagay mo ang kanyang buong pangalan. But of course, not all the time you know the name or the surname, you know the name and the surname of your accused, because kahit nga dyan sa mga inyong village or where you live, you do not know the full name of your neighbors. Ang alam mo lang, katabi mo si Mang Kanor, katabi mo sila Mang Tomas, or di kaya kilala mo si Kuyang Magtataho, but you do not know his full name. So in that case, the rules allow you to use any appellation or nickname by which he has been or is known. Next, if the name cannot be ascertained, like for example, nasnatchan ka dyan sa Quiapo, nasnatch ang cellphone mo. So most likely, hindi mo kilala kung sino yung taong nag-snatch. You do not know his name. So what is the rule saying to us? He can be described, or that accused can be described under a fictitious name with a statement that his true name is unknown. Again, you can describe the accused under a fictitious name with a statement that his true name is unknown. Next, if the true name is thereafter disclosed, nahuli ng pulis, therefore, if the true name of the accused is thereafter disclosed by him or appears in some other manner to the court, then the true name shall be inserted in the complaint or information and record. Next is the designation of the offense given by the statute. This is your section 8 of your Rule 110. The complaint or information should state the designation of the offense given by the statute. So kung ang tao ay nakapatay, then it's either Article 248, that is murder, or Article 249, that is homicide. So walang problema kung yung kaso is under the revised penal code because most likely meron namang mga designation dyan. But in special laws, wala masyadong designation. Kaya ang sinasabi ng rules, if there is no designation of the offense, then you can make a reference. Reference shall be made to the section or subsection of the statute punishing it. Just like for example, in this information, ang ginawa ng akusado is violation against women and children. Since there is no designation, then reference was made to Section 5, letter A of RA 9262. Ano ba itong Section 5, letter A? That is causing physical harm to the woman or her child. So this is an example of reference to the section or subsection of the statute. Next, the complaint or information should also aver the acts or omission constituting the offense, and lastly, it should specify its qualifying and aggravating circumstances. So this is very important because if you are not able to specify the word, take note, the word used is specify, hindi lamang alleged, but you have to specify. You have to put the specifics of your qualifying and aggravating circumstances. So kung hindi mo na ilagay yung qualifying, like for example, you were not able to put in your information treachery, then you cannot convict that accused of murder. Pwede lang siya sa homicide because these are the crimes that would be qualified. And famous dyan is from homicide to murder. Another one is from theft to qualified theft. So aside from the name of the accused as well as the designation of the offense given by the statute, you have to state also the acts or omission complained of as constituting the offense. This is your section 9 of your rule 110. So what is the requirement of the rule when it comes to acts or omissions? Take note that it should be stated in an ordinary and concise language and not necessarily in the language used in the statute. Again, it should be stated in an ordinary and concise language. You have to make sure that it will enable a person of common understanding what offense is being charged. It should enable a person of common understanding to know what offense is being charged. Ano ba itong acts or omission? If you compare this to your civil case, actually this is your cause of action. Diba sa civil cases, every ordinary civil case must be based on a cause of action. And what is a cause of action? It is an act or omission by which a party violates a right of another. So this is the equivalent of your section 9. We'll go now to number 4, the place where the offense was committed. This is your section 10 of your rule 110. So a complaint or information is sufficient if it can be understood from its allegations that the offense was committed at some place as long as it is within the jurisdiction of the court. Or a complaint or information is sufficient if it can be understood from its allegations that some of the essential ingredients occurred at some place within the jurisdiction of the court. So why do you need to put the place in your information? The purpose of that is to show the territorial jurisdiction of the court. Pwede kasing yung krimen nangyari sa Cebu, but yung case final dito sa Metro Manila. Therefore, walang territorial jurisdiction ang Metro Manila. Because again, remember, relate this to your section 15 of your rule 110, place where action is to be instituted. Letter A, subject to existing laws, the criminal action shall be instituted and tried in the court of the municipality or territory where the offense was committed or where any of its essential ingredients occurred. Remember ha, in criminal cases, venue is jurisdictional. Venue is jurisdictional. Therefore, it should be filed where the offense was committed. Let me just give you an example of this, some of the essential ingredients. Common to sa violations of BP 22, BP bilang 22. Remember that your violations of BP bilang 22 is categorized as transitory or continuing crimes. This is a transitory or continuing crimes. Therefore, maraming court ang pwedeng mag-acquire ng jurisdiction. A suit of BP bilang 22 can be filed in any of the places as long as the element of the offense occurred in that place. So it could happen where the check is drawn. So kung in-issue yan sa sa Quezon City, but it was delivered in Pampanga and it was dishonored in Baguio, so pwedeng magkaroon ng jurisdiction ang isa sa mga lugar dyan. So that is the importance of BP bilang 22. Next, there is an exception There is an exception. Ang sinasabi ng rules, if the place constitutes an essential element of the offense, then hindi lamang pwedeng ilagay ang place. Dapat you have to specify the place, or you have to put the place with particularity. Again, if the place constitutes an essential element of the offense, or the place is necessary for its identification, then you have to state the place with particularity. Example, yung Article 280, qualified trespass to dwelling. So one of the elements of qualified trespass to dwelling is that the offender enters the dwelling of another. So we can see that place is an essential element of Article 280. Therefore, the requirement of the rule, since this is an essential element, you have to state in your information the place with particularity. Number 5 is the approximate date of the commission of the offense. Again, the approximate date of the commission of the offense. This is your section 11. Ano ang sinasabi ng rules? It is not necessary to state in the complaint or information the precise or the exact date the offense was committed, except kagaya din ng place. If date is a material ingredient of the offense, then you have to state the date. Like for example, in an election offense or in an infanticide, so you really have to state the exact date. The offense may be alleged to have been committed on a date as near as possible to the actual date of its commission. So again, for a complaint or information to be sufficient, it should state the name of the accused, the designation of the offense as given by the statute, the act or omission complained of as constituting the offense, the place where the offense was committed, the approximate date of the commission of the offense, and lastly, number 6, the name of the offended party. This is your section 12 of your rule 110. So the complaint or information must state the name and surname of the person, the name and surname of the offended party, whether it is a crime against person or a crime against property. And just like the rule in the name of the accused, if you do not know his full name, then you can use appellation or nickname by which such person has been or is known. And if there is no better way of identifying the offended party, then he can be described under a fictitious name. Next, if it is a crime against property or offenses against property and the name of the offended party is unknown, then you can describe with particularity the property. The property must be described with such particularity as to properly identify the offense charged. And if the name of the offended party is unknown, or you described him under a fictitious name and later on it is disclosed or ascertained, then the court, the same rule sa name of the accused, the court must cause the true name. It should be inserted in the complaint or information and the record. What happens if it is if your offended party is a juridical person? The rule states that it is sufficient to state the names or any name or designation by which it is known or by which it may be identified. There is no need of averring that it is a corporation, or it is a partnership, or it is a juridical person, or that it is organized in accordance with law. So what happens if your complaint or information does not state all of these 6 items? Hindi kompleto itong 6 items. Then what you can do as early as now, I will tell you that you can file motion to quash. That is your Rule 117. And what is your ground? That is letter E rather, that the complaint or information does not conform substantially to the prescribed form. So you can file your motion to quash before entering the plea, or before the accused will enter his plea. Then the accused may move to quash the complaint or information. Again, the ground is the information or complaint does not conform substantially to the prescribed form. But what about in an instance wherein there is a defect in a complaint or information? Like for example, malabo yung sinasabi na acts or omissions, hindi mo maintindihan. Then what is the remedy of the accused? Take note that you can file a bill of particulars. That is your Rule 116, Section 9. The accused may, before arraignment or before he enters his plea, he can move for a bill of particulars to enable him properly to plead and prepare for trial. This is similar to your Rule 12 of your civil procedure. Same yung concept niyan. And that motion for bill of particulars should specify the alleged defects of the complaint or information and the details desired. But of course, if you are the lawyer of the accused, magfa-file ka ba ng bill of particulars? Diba? Gusto mo naman na maging malabo yung information because that would rule in favor of your client. That would rule in favor of the accused. Merong defect ang information, then it might create a reasonable doubt. But again, I just have to tell you that there is a bill of particulars, or bill of particulars is available in criminal cases as well as in civil cases. Before I end, let me just tell you that in criminal cases, ang point of reference is before arraignment. Diba, ang point of reference in civil cases is before the defendant files his answer. Here, in criminal cases, the point of reference is arraignment. Before arraignment, you can file a motion to quash. Before arraignment, you can file a motion for bill of particulars.